Hello and good evening. Welcome to our presentation. We are from group S3-07 and my group members are Amin Maharjan, Umesh Thapa and myself Milan Maharjan. We are going to present on the case study of business and corporate law. There are two parts, A and B, and we are choosing option 1 from part A and option 2 from part B. My next slide is Sue Burgers versus Mikey and Brett. It's from part A, option 1. The issues are whether Sue Burgers is responsible to provide Mikey with a car under the contract law, and another issue is whether Sue Burgers is responsible to provide Brett with the car under the contract law. These are two issues. The rules applicables are for Mikey in Parties versus Crittenden 1968 case. It was held that the advertisements which are seen as being published in newspaper or any other forms of media should always be considered to be invitation or offer and not actual offer. Following this judgment, it can be seen that an individual who has published an advertisement is not legally bound for following the advertisement. Next one is, according to the decision of Carlyle versus Carbolic Smoke Ball Company, an advertisement which can be seen as containing any kind of term of reward is required for being treated as an offer that is binding towards the offerer for any individual accepting the offer. The judgment of the case provides the description of an offer to be proposal given by one of the parties for any specific arrangement to the other party, and when the party to whom the offer is made is seen to be making the declaration of acceptance of the offer in written or oral way, it is called acceptance of the offer. Another one is the judgment of Bryan versus Van Tenhoven and Company in 1888 held that the revocation of the offer is required to be made before the offer has been accepted, and the notice for the revocation is needed to be communicated to the offeree in a direct and indirect way. And last one is in Dickinson versus Dodds in 1876, the judges held that the revocation of any offer is not necessary for being communicated by the individual making the offer to the offeree in a personal or direct manner. These are the rules applicable for the cases. The next slide is rule applications applicable for the Brett case. In the same case, Practice versus Crittenden 1968, it was held that the judges in the court that the advertisements which are seen as being published in newspaper or any other forms of media should always be considered to be invitation to offer and not actual offer. According to the decision of Carlyle versus Carbolic Small Ball, an advertisement which can be seen as containing any kind of term for reward is required for being treated as an offer that is binded towards the offerer for any individual accepting the offer. According to the Appleby versus Johnson 1874, a contract is only seen as forming between the two parties when the offeree accepts the offer in oral or written terms. In Piney versus Cave 1789, it was held by the judges that the withdrawal of an offer can be done only by way of revocation process when there has been no acceptance made by the offeree. This is the rule applicable for the Brett application. The next slide is application for Mikey. Following case Parties versus Crittenden, it is being seen that Sue Burgers is not required for being bound by the advertisement that they have published. Instead of being a real offer, the advertisement is considered as being an invitation to offer. However, the following decision of the judge in Landmark case, it is observed that the advertisement which Sue Burgers have published had one term for the reward of a car to any of the individuals winning a golden scratch card, so Sue Burgers advertisement can be considered to be an offer for anyone accepting it. Following Bryan versus Van Tenhoven and Company, in this given scenario, it can be seen that Mikey had been admitted in the hospital and he was not able to be hearing the official notice for revocation of the offer by Schooberger's offer, and hence the revocation would not be effective towards him. However, applying the judgment in the case Dickinson versus Dodds, it can be observed that Mikey had been hearing the discussion of the nurses in passing about the revocation of the Schooberger offer, hence the revocation would be effective to him. Next is the application for the Brett. Following the judgment of parties and Crittenden case, it is being seen that Schooberger is not required for being bound by the advertisement that they have published. However, following the decision of judges in landmark case of Cargill versus Carbolic Smallville, it is observed that the advertisement which Schooberger had published had one term of the reward, so the Schooberger advertisement can be considered to be an offer for anyone accepting it. As per Appleby versus Johnson, Brett had presented the winning tickets before the announcement of the revocation, so his acceptance is valid. Applying Pine versus K in the current scenario, it can be seen that Brett already accepted the offer of and Schooberger's revocation would not be affect him. This is the application for the Brett. Now conclusion. My friend Amin will continue with the conclusion. Thank you.
Hello, my name is Amin, and now I'm here for the conclusion regarding the Schoobergers and the Mikey. And the conclusion is Schooberger is not responsible to be providing Mikey with the car Mazda CX-9X under the contract law, whereas the Schooberger is responsible to provide Brett with the car Mazda CX-9X under the contract law. Moving on the next slide, now I would like to speak on the part B, option 2, regarding the Flex versus Mercedes and the Gerg. The first issue in this scenario is whether the Mercedes can be held liable for the breach of directors' duties under the Corporation Act, and the second issue is the scenario is whether the Gerg can be held liable for the breach of the directors' duties under the Corporation Act. As per the law for the Mercedes, Section 180 of the Corporation Act 2001 mentioned the duties that the director is required to the following for acting on with required degree of care and diligence. The provision of the section was seen as being discussed in Sino Australia Oil and Gas Limited versus Sino Australia Oil and Gas Limited 2016. In the landmark case ESIC versus Rich 2009, the business judgment rule mentioned in the provision of section 182 was established that can be seen as providing that any director of any company would meet the requirements present in the section 181 if they are seen as taking as a business judgment for a proper purpose in good faith. They are not seen having any type of material interest. They have made themselves informed about the subject matter for which the judgment is taken up to such an extent that would be believed to be appropriate reasonably. They have believed in a rational manner that the company's best interest would be ensured by the judgment. Under the section 588G, the duties of any director to act in the prevention of the company's insolvent trading during his has been mentioned in the famous case Torprint versus Bot 1999. This section was seen to be discussed. Section 588GA provide with protection to the director of company by way the descent of safe harbor. Under the law for the Greg, section 180 of the CA 2001 mentioned the duties that a director is required to be following for action with the specific degree of care and diligence. This section was seen as discussed in the judgment of case Sino Australia Oil and Gas Limited versus Sino Australia Oil and Gas Limited. Under the provision of section 588G of the CA 2001, the duties of any director to act in prevention of companies trading during has been mentioned in the famous case Torprint versus Port 1999. This section was seen to be discussed. Section 588GA provides with the protection to the directors of the company by way of defense of safe harbor. Under the provision mentioned in the section 181 of the CA 2001, the duty of director has been to be acting in good faith for the company's best interest as mentioned in the case Bell Group Limited versus Westpac Banking Corp. Now for further presentation, I would like to call Umesh Thapa. Thank you.
Thank you, Amin. Hi, I am Umesh, and I'll lead you through the rest of the slides. The first one is like the application on Mercedes. Following Section 180 of the Corporation Act 2001, Mercedes can be seen in breach of this section, applying the judgment of the case Sino Australia Oil and Gas Limited versus Sino Australia Oil and Gas Limited. In this scenario, it can be seen that the requirement to be exercising their powers with such due diligence and care that can be expected from any rational individual was also not followed by her. However, her decision can be protected under the business judgment rule mentioned under the section 180 subsection 2 of the Act. As a director, Mercedes has the duty to be preventing the company from trading in insolvency under section 588G as discussed in the judgment of the case Torpint versus Bott 1999. However, section 588G could provide Mercedes with protection by way of defense of safe harbor. And the application and charge will be following the provisions of section 180. The grave can be seen to in breach of the section as discussed in the case Sino Australia Oil and Gas Limited versus Sino Australia Oil and Gas Limited 2016. As a director, Greg has the duty to be preventing the company from trading in insolvency under section 588G as discussed in the judgment of the case Torpint versus Bott. However, section 588G could provide Greg with protection by way of defense of safe harbor. Applying to the provisions mentioned in the section 181 of CA 2001, Greg can also be found liable for the breach of the duty of acting for the company's best interest. The conclusion will be Mercedes will be held liable for the breach of section 180, 182 and 580G under the Corporation Act. However, she has the protection under section section 180 subsection 2 and 588G. And the Greg would be held liable for the breach of section 180, 181 and 588G under the Corporation Act. He will be protected under section 588G. And those are the representations of all the case history we followed. That will be all from us. Thank you. Have a good one.